In this lesson, we're going to be talking about the fundamentals of 42 CFR Part 2 and substance use disorder treatment privacy. My name is Desiree Cochran Norfolk. I am a master addiction counselor through the Georgia Addiction Counselors Association. For over 50 years, federal law has protected the confidentiality of people who seek treatment for substance use disorders. The privacy law and its implementing regulations, which is 42 USC 290DD-2 and 42 CFR Part 2, they're commonly referred to together as just simply Part 2. The Health Insurance Portability and Accountability Act of 1996, which we lovingly refer to as HIPAA, is a federal law that requires the creation of national standards to protect sensitive patient health information from being disclosed without the patient's consent or knowledge. The U.S. Department of Health and Human Services, which we call HHS, issued the HIPAA privacy rule to implement those requirements of HIPAA. The HIPAA security rule protects a subset of information, which is covered by that privacy rule. So there are a couple individuals and organizations that are subject to the privacy rule, and they're considered covered entities. So the first one would be healthcare providers. Every healthcare provider, regardless of the size and of the practice, who electronically transmit health information in connection with certain transactions is going to be subject to this. And these transactions can include claims, benefit eligibility inquiries, referral authorization requests, other transactions for which HHS has established standards under the HIPAA transactions rule. Another entity would be health plans. So these will include health, dental, vision, prescription drug insurers, health maintenance organizations or HMOs, Medicare, Medicaid, Medicare Plus Choice, Medicare Supplement insurers, long-term care insurers, including it excludes nursing homes, which have fixed indemnity policies, employer-sponsored group health plans, government and church-sponsored health plans, multi-employer health plans. Now, there is an exception here. A group health plan with fewer than 50 participants that's administered solely by the employer that established and maintained the plan is not a covered entity. Another entity would be healthcare clearinghouses. These are entities that process non-standard information that they receive from another entity into a standard format or data content or vice versa. In most instances, these healthcare clearinghouses receive individually identifiable health information only when they're providing these processing services to a health plan or a healthcare provider as a business associate. Another entity covered would be a business associate. So this is a person or an organization other than a member of the covered entity's workforce that uses or discloses individually identifiable health information to perform or provide functions or activities or services for covered entities. So some of these functions or activities or services include claims processing, data analysis, utilization review, billing, things like that. If you have a Google backend for your business or something, you have to have a business associate agreement with them. They have to become a business associate for you, and they have to sign that agreement to have it be covered under HIPAA. So the standards for privacy of these individually identifiable health plans, which falls under that privacy rule, it establishes for the first time this set of national standards for the protection of certain health information. So HHS issued the privacy rule to kind of implement the requirements of HIPAA in 1996. And this privacy rule standard addresses the use and disclosure of people's health information. It's called protected health information, or PHI. And this is protected by organizations, and it's subject to the privacy rule. we call them covered entities, as well as the standards for individuals' privacy rights to kind of understand and control how their health information is used. So within HHS, the Office for Civil Rights, or the OCR, has the responsibility for implementing and enforcing the privacy rule with respect to any voluntary compliance activities and civil money penalties. But the major goal of the privacy rule is just to ensure that individuals' health information is just properly protected while allowing the flow of health information that's needed to kind of provide and promote high quality health care and to protect the public's health and well-being. So this rule, it just strikes a balance that kind of permits important uses of information while also protecting the privacy of people who are seeking care and their healing. So given that the healthcare marketplace is diverse, the rule is designed to be flexible and comprehensive to cover the variety of uses and disclosures that need to be addressed. And patients do have certain rights under the privacy rule regarding their PHI. So first, they have the right to access their information. The HIPAA privacy rule generally provides people with legal enforceable rights to see and receive copies upon their request of any information in their medical or other health records that are maintained by their healthcare providers or their health plans. And this is known as the HIPAA right of access. And the privacy rule generally requires HIPAA-covered entities to provide individuals, when they request it, with access to their private health information about them in one or more designated record sets that's maintained by or for the covered entity. So a designated record set is just defined as just a group of records that's maintained by or for the covered entity that will comprise the medical records and the billing records about the individual, either that's maintained by or for the covered healthcare provider. It's going to include enrollment, payment, claims adjudication, and also case or medical management record systems that are maintained by or for a health plan, or any other records that are used in whole or in part by or for the covered entity to make decisions about individuals. So these records in a designated record set are going to include medical records, billing and payment records, insurance information, clinical laboratory test results, medical images like x-rays, wellness and disease management program files, and also clinical case notes. So the HIPAA right of access is going to include the right to inspect or obtain a copy or both of the PHI in a designated record set. And these patients, they also have the right to direct the covered entity to transmit a copy to a designated person or an entity of the individual's choice. Like say they want to have their records sent to their doctor or to another provider. We have to do that. So the HIPAA right of access applies to this PHI for as long as the information is maintained by the covered entity or by the business associate on behalf of the covered entity, regardless of what the format the information was obtained in, or when it was created, or where it was originated. So in Georgia, we only have to house these records for up to 6 years. But generally, a patient has the right to amend their PHI or a record about the individual in a designated record set for as long as that PHI is in the designated record set. But we want to note that this is just generally the same information that an individual is entitled to access under their rights of access. So a covered entity has to permit the individual to request that the covered entity amends the protected health information that's maintained in that designated record set. And while the business or the person or whoever's that covered entity may require the patient to make requests for the amendment in writing, and we can also ask them to provide a reason to support a requested amendment. We have to inform the patients of these requirements in advance. So if the patient makes a request to amend their PHI, the covered entity has to grant the request unless a specific HIPAA privacy rule provision allows for us to deny the request. The covered entity also has to inform the patient of its decision to either grant or deny the request within 60 days after we've received the request. And if the covered entity grants the request, they have then to make the appropriate amendment to the PHI or the record that's subject to the amendment request, at a minimum of identifying the records in the data set that are affected by the records, and then appending or otherwise providing a link to the location of the amendment. In addition to that, if the covered entity agrees to make the amendment, the covered entity must timely inform the patient that the amendment is accepted. And lastly, the covered entity has to make reasonable efforts to just inform and provide the amendment within a reasonable time to the persons that are identified by the individual as having received the PHI about the individual and needing the amendment. So the administrative requirements, including safeguarding the client's information, this is going to mean that covered entities must have in place an appropriate administrative or technical and physical safeguard to protect the privacy of that PHI. They have to reasonably safeguard protected health information forms. We have to reasonably protect from any intentional or unintentional use of disclosure that's a violation of standards, implement specifications or other requirements of the subparts of the rule. And also, the covered entity must be able to reasonably safeguard the PHI to limit any incidental uses or disclosures that are made pursuant to any otherwise permitted or required use of disclosure. So now let's move into the security rule. The security rule kind of protects a subset of information covered by the privacy rule, which is all individually identifiable health information that any covered entity creates, or they receive, or they maintain, or they transmit in any electronic form. So the security rule calls this information electronic protected health information, or ePHI. So really quickly, I'll touch on this and I'll get into this a little bit later, but the HIPAA breach notification rule requires HIPAA covered entities and their business associates to provide notification following a breach of any unsecured PHI. So Part 2 generally requires a patient's written consent before making a disclosure of any protected records. The patient consent always has to be written, and it includes specific information about the recipient of the records and the records to be shared. So written consent needs to be obtained to disclose information. There are a few exceptions to this rule that I'll discuss with you guys later, but we're going to discuss court orders and authorizing disclosures. We'll discuss all of that in a later lesson. So we have to comply with the most restrictive law. And so most healthcare providers that are engaged in substance use treatment need to comply with both HIPAA and Part 2. And where the laws conflict with each other, or maybe they conflict with the state law, we have to comply with the most restrictive state law. And the law that gives the greater protection to the patient's information, or we need to stick to the law that gives greater control of their info to the patient. So we can kind of see on this chart that first we comply with state law, and then HIPAA, and then Part 2, because Part 2 is typically the most restrictive. The minimum necessary care, I kind of want to break this down here and not in the other lesson where I talk about the differences between the two, because I want you guys to understand that there is a minimum necessary Under HIPAA, we have to limit any permitted use or disclosure of PHI to the minimum necessary. Now, there are exceptions like disclosure to another provider for treatment purposes or disclosure to the patient. But under Part 2, we have to limit disclosure to the info necessary for permitted purposes of disclosure. So, for example, if a client wants us to disclose to their probation officer that they are starting and or ending treatment, then that is all that we can give them. We can't give the probation officer any more information than when the client started and when they completed, or if they're in compliance. That's pretty much the extent of what we can do if they've only given us that particular purpose of disclosure. Now, if they say we can disclose case notes and things like that, then we would be able to do that as well. But typically, we're only limited to the information necessary for the permitted purpose of the disclosure. So, why is it important to people living with substance use disorders? Confidentiality is a cornerstone of any treatment relationship. So for people receiving substance use disorder treatment, strict confidentiality protections mean that you can share information about past and current drug use without worrying that it's going to be used against you by the police or a landlord or an employer or a judge or a social worker or your mama, So for people who consider whether or not to enter treatment, there have been research studies that consistently show that confidentiality and privacy are major considerations. And until we've eliminated the stigma and the criminalization of substance use disorders, patients really need the right to access their treatment without worrying that their record is going to be used against them to take away their children or their housing or their employment or their insurance or their public benefits or even their freedom. There's been many different organizations and hundreds of the nation's top SUD treatment and recovery and healthcare and advocacy organizations that strongly support Part 2's core confidentiality protections. It's more important than ever to understand and protect our patients' privacy rights as the privacy protections increasingly come under attack. So Part 2 only protects substance use disorder treatment records from certain types of federally assisted programs, which are known as Part 2 programs. So if you receive SUD services from a non-Part 2 program, then your treatment records are not protected by Part 2, although you still have rights under the HIPAA and state laws, but it wouldn't be covered under Part 2. So patients really need to ask their provider, and providers need to make it known if they are a Part 2 program. And if the providers have questions about whether they are a Part 2 program, they can access resources and technical assistance. There's a place called Center of Excellence for Protected Health Information. That's a great place to start. So how does it work? Part 2 generally requires a patient's written consent before making a disclosure of protected records. You can't say, oh, well, they just told me that I could say this to their mom. No, it has to be in writing. The patient must always consent in a written form and include specific information about the recipient of the records and the records that are to be shared. So for an example of Part 2, compliant consent form, you can see the sample that I've put in the records in your lessons. It's called Consent Authorizing Disclosure of Part 2. And that's going to be located in your lesson underneath this video. So let's talk a little bit about administrative requirements. Under HIPAA, you have to designate HIPAA privacy and security officers. You have to implement policies and safeguards, train your workforce, respond to any complaints, and you actually need to put that in your documentation. It needs to be written and accessible to the client. They need to be given a copy of it, and you need to have it posted somewhere on the wall where they can complain. You need to mitigate any violations. maintain your documents that are related to HIPAA compliance for at least 6 years. And Part 2 just doesn't address administrative requirements, so we follow HIPAA here. And this is where things get tricky. So some facilities want the clients to display their ID cards when they're walking around. Like, let's say we're in a inpatient treatment facility and you want your client to display an ID card, or you want to have a wristband or something with their identifiable information on it so that we can make sure that we're treating the right client. So you may require ID cards within a program, but you may not require the ID cards away from the program. When we're talking about discrimination, we want to make sure that we're not discriminating against clients, but Part 2 is going to add explicit protections against discrimination in the records or information about the patient that's disclosed under Part 2, either inadvertently or intentionally. So specifically, no entity may discriminate against the patient with whom the Part 2 records relate in admission or access to or treatment for health care, in hiring or firing, or the terms of employment, or the receipt of workers' compensation, any sale, rental, or continued rental of housing, access to federal, state, or local courts, access to approval of or maintenance of social services and benefits that are provided or funded by the federal, state, or local governments, and no recipients of federal funds may discriminate against the patient based upon Part 2 records in affording access to the services provided with such funds. So basically, even if they can't pay, we can't discriminate against them. And there are penalties and enforcements. Part 2 has historically been enforced criminally by the U.S. Attorney, and penalties under Title 18 of the U.S. Code, which is 42 CFR Part 2.3. And the penalties under Sections 1176 and 77 of the Social Security Act, there are penalties listed there imposed for HIPAA violations. And so if we have a HIPAA violation unknowingly, the range of penalty is between $100,000 to $50,000 per violation, with an annual maximum of $25,000 for repeat violation. If the violation was a reasonable cause, the penalty ranges from $1,000 to $50,000, with an annual maximum of $100,000 for repeat violations. And if it was a willful neglect, but the violation is corrected within the required time period, the penalty range is $10,000 to $50,000 per violation, with an annual maximum of $250,000 for repeat violations. So this is extremely important that we are not violating HIPAA laws, because you could go out of business. So if there was willful neglect and it's not corrected within that required time period, the penalty for that is $50,000 per violation. And there's an annual maximum of $1.5 million. There are criminal penalties. So knowingly is going to mean that you obtained or disclosed individually identifiable health information in violation of the administrative simplification regulations, and you're going to face a fine up to $50,000 as well as imprisonment for up to 1 year. Offenses committed under false pretenses are going to allow penalties to be increased to $100,000 per fine, with up to 5 years in prison. And then any offenses that are committed with the intent to sell or transfer or use that individually identifiable health information for commercial advantage or personal gain or malicious harm permit fines of $250,000 and imprisonment for up to 10 years. So that's a huge penalty that I would not want to risk for myself. You can find additional resources on these websites here, so feel free to pause and write them down, or print the PowerPoint out for yourself and type these in. These are some great resources to figure out the laws, the regulations, and things of that nature. I'm also going to provide the links directly in the lesson below. Here's my contact information if you're having any technical difficulties with the course, or if you have any questions or thoughts about the program or the content, please feel free to reach out to me at any time.